Good afternoon, everyone. This is Jonathan Pollard of Pollard Financial Coaching and Gen Y Financial Freedom coming to you this November 15th, 2014 with the Daily Dollar. And today's Daily Dollar is about estate planning for the not so wealthy. And I got the idea to do this video from some of the videos that I've done most recently about life insurance and disability insurance. And I also got the idea from some divorce work that I did over the past 2 days for a client of mine. And I started thinking about how, in keeping with the whole concept of protecting yourself to the downside, I wanted to tell you guys about, the documents that you need in order to protect yourself and to protect your family. And prepare them for the future in the event of your untimely demise. So when I say estate planning, I mean I'm referring to 3 specific documents. Unfortunately for you guys, only only one of those documents requires that you go see an actual attorney in order to have it drafted, or I recommend that you go see an attorney to have it drafted. So let's get right into it. The first document is a will. And this is the document that I do recommend that you consult with an attorney about in order to have drafted, just to make sure that it's executed in the proper fashion and that it's valid, in the event that it needs to go to court. Right? The purpose of a will is to make sure that your assets are divided up in the way that you would like them to be in the event of your death. In a will, you usually name what's called an executor or an executrix, and those are just legal terms for the person who will correspond with the court, the person who will be a liaison with the court after your will is admitted to probate to determine the validity of it. One of the main reasons that people with children in particular, even if they don't have a whole lot of assets now, if they have any potential of acquiring assets in the future, they should have a will, because you want to designate who you want to be the guardian of your children in this particular will. When a person dies, and a child is without a parent, and they're looking to whom they should grant custody of that particular child, if he or she is a minor, they look to the best interest of the child. And having a will and having a specific guardian in that will for the children in the event of your death will be a good piece of evidence for the courts to determine that granting custody to that person who you named as a guardian is in the best interest of a child. Another thing that you can do with a will that makes it somewhat flexible is that you can attach a testamentary trust. Now, I'm not going to get into the whole legal rigmarole behind what a testamentary trust is right now. You can consult with your attorney about that. But just suffice it to say that if you acquire any assets in the future and you want them to be distributed to your children in a certain way, prior to them turning 18 or prior to them reaching whatever age, after your death, you can name trustees in a trust, and usually those trustees will be people that you trust, people that you think are responsible with money and who care for your children also, and who will do right by them. Right, so with a will, you can have a testamentary trust, which is sort of like think of it as a bag that holds all of your assets, and you can control how those assets are distributed from the grave or before you hit the grave, rather, by designated trustees in that trust. The next document that I think is very, very important for people to have, and it's one that I do not think you need to consult with an attorney about in crafting, is a New York State, well, actually, no, that's a little bit too specific, a general healthcare proxy. If you Google New York State healthcare proxy, if you're in New York, you'll find the form, and you can just fill it out and have it signed by yourself and 2 witnesses, and neither of the witnesses can be the healthcare agent that you designate. But I don't know how it works in other states. I imagine that there is a form for other states, but if you're in another state, you might have to consult with another attorney. But if you're in New York, you don't need to consult with an attorney to do this. But A healthcare proxy is basically a document that gives your quote unquote healthcare agent, a person who you designate, the ability to make life altering medical decisions for you. So let's say you're driving along and you get into a car crash, God forbid, and your body is living, but your brain is dead. Right? You know, who's going to decide whether or not to pull the plug? Who's going to decide whether or not you should still receive life sustaining treatment? Now, usually some hospitals will look to the next of kin or a spouse, but let's say you know, dad gets into an accident and is brain dead, like I said, and then mom wants him to live, but the kid said that he told them privately that you know, he wants the plug pulled. He doesn't want to be artificially sustained or on life support. You know, whose vote governs, right? Is it the spouses? Is it the children's? Having a healthcare proxy eliminates all the need for, you know, for the bickering about what to do, because you specifically designate what you want done. All right. So, like I said before, if you're in New York State, you can just Google New York State healthcare proxy form, and you don't need an attorney to fill it out for you. You just follow the instructions. It's like filling out an application. You sign it, and you need to have it witnessed by 2 people who also will sign, but you do not need to have it notarized. The last document that I want to talk about is what's called a durable general power of attorney. Once again, if you're in New York State, there is a form online that you can Google and fill out, thus you know, eliminating the need to consult with an attorney. Now, on a durable general power of attorney form, you can give your person who you're appointing as your attorney in fact, or your agent, the ability to do certain things for you. And if you look at the form, the things that you can, the powers that you can give them are enumerated. So you can say, I only want my attorney in fact to be able to engage in real estate transactions for me, or I only want them to be able to go to court and speak on my behalf, or I only want them to be able to write checks for me, and so on and so forth. What you will not find on a durable general power of attorney form is a box granting your agent or your attorney in fact the power to make life altering medical decisions for you. And that's why there's a necessity for the healthcare proxy that I just spoke about. A durable general power of attorney is very, very important, just like a healthcare proxy for spouses to have, or if you're not married, particularly if you have a spouse, because let's say you and your husband own property jointly, and your husband becomes mentally incapacitated, all right, and you do not have a durable general power of attorney form. If you guys own property together and you want to sell it, you can't sell it without his signature, all right, because he's incapacitated, right, and you know, and therefore he's incapable of entering into contracts. So what do you do when you own property with someone who's incapacitated and they can't sell it? The short answer is that you have to go to court and go through a whole lot of litigation and have essentially what's called a guardian appointed for that incapacitated person. And you just don't want to have to go through that. So having a general power of attorney form executed by both spouses makes things a whole lot easier in terms of selling assets in the event one spouse gets incapacitated. And it's particularly important because a lot of times spouses just assume that because they are a spouse of a person that they can just handle that person's affairs. Not so, unfortunately. So that's why I encourage all of you guys to, particularly if you're married, to have a durable general power of attorney form and a healthcare proxy form and a will. Yeah, just to recap, I only think that you need an attorney for the creation of a will, and that's because courts look to specific things in wills to determine their validity, and you don't want to, you don't want your assets to just go to any old person just because you drafted a will improperly. But with the healthcare proxy and a durable general power of attorney, those are pretty much, for lack of a better term, foolproof. And anybody, with reasonable intellect can fill out these forms. I hope you guys enjoyed this. If you have any questions or comments or suggestions, criticisms or observations, please feel free to email me at jcp182000 at yahoo.com. Thanks so much and stay tuned.